Thank you. Welcome and thank you for joining Part 5 of Seyfarth's micro-webinar series, Partnering for Success, a cross-practice series on top legal considerations for government contractors. This installment of the series will focus on real estate contracting with governmental entities. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Krista Dahmers. Krista, you may begin.
Thank you, Brooke. Welcome to the webinar. My name is Krista Dahmers. I am the managing partner of the Washington, D.C. office of Seyfarth Shaw, and I'm a real estate attorney who practices primarily representing government contractors with their real estate needs, including in connection with leasing from either the federal government on federal lands, whether that be military bases, airports, or other installations, or from state and local governments in connection with either incentive projects or on just municipal lands for various reasons. With that, I will turn it over to Stephanie so she can introduce herself.
Hi, I'm Stephanie Magnell. I am a senior counsel here at Seyfarth in the Government Contracts group. I've been here for about 2.5 years, and prior to that, I was a GAO hearing officer for about 7 years, dealing with bid protests, and before that, I was a trial attorney at the Army. And my practice focuses on largely on the interactions between business and the government, primarily at the federal level, but also at the state level. And today I wanted to talk with you a little bit about sovereign immunity and how that interacts with with leases by the government and leases to the government. So we're going to talk about first principles here. Historically, the sovereign, the king or queen back in the day, was immune from suit. So, and we've carried that principle forward. So right now, the government, including federal, state, and local governments, were presumed to be immune from suit. Now, skipping over a fair bit of history, today parties can bring suit against the government in certain instances, including the lease transactions we're going to talk about here. However, the government can really only be sued to the extent that it has permitted to be sued. So that's where we stand today. That's a pretty broad brush, but and we will take a little closer look at it in the time we have today. Next slide. So one of the places that the government has allowed itself to be sued, the forum, is the Court of Federal Claims. The Court of Federal Claims was formed in 1855 to relieve Congress from the burden of responding to individual claims. So Congress was receiving a number of claims and did not want to have to address all of those in addition to their other duties. The principle of sort of allowing the government to be treated a bit like a commercial party, not completely, was supported by President Lincoln in a pretty well-known quote from 1861, where he said, "It is as much the duty of government to render prompt justice against itself in favor of citizens as it is to administer the same between private individuals." So in that line, the Tucker Act, which was first passed in 1887, now codified at 28 U.S.C. 1491, which gives the Court of Federal Claims jurisdiction over certain claims. It's really one of the primary statutes that allow a contractor to bring suit against the government in a number of contractual circumstances. And it has been held that by giving the Court of Federal Claims jurisdiction over these types of claims, it is expressly a waiver of the sovereign immunity. So what has happened is that the government has, as we talked about earlier, consented to being sued in the Court of Federal Claims. And we'll go to the next slide. So just wanted to touch on some early case law that I found particularly interesting. US v. Lee is a case that resulted in the United States obtaining the land that has now become Arlington Cemetery. And if you're here in Washington, D.C., that's a really special place to go. But it did belong to the Lee family once upon a time. They didn't pay the taxes, and the U.S. government bought it at auction. And this is the case that was looking at whether or not they could bring suit. And the Supreme Court held that any suit against the United States or any of its agencies must be, again, based on a particular statute that waives the sovereign immunity for the particular type of claim made and must follow the specific statutory regulations. And the suing party has the burden of demonstrating the right to bring the particular action. So when you're thinking about sovereign immunity and when can you start to, you're going to engage in some sort of lease transaction, what are going to be your rights against the government? You need to remember that those rights aren't going to be the same types of rights, the same breadth, frankly, of legal actions that you can bring against the government. That you don't have the same breadth as you have against a private party. You're going to need to find a statute that allows you to bring a suit to redress the specific type of harm you're seeking, and you're going to need to pursue that in the correct forum. Okay, if we go to the next slide.
So just wanted to add some of the nuances that Stephanie mentioned earlier. There's really two types of governmental immunities. There's sovereign immunity, which Stephanie had mentioned, and it's often subsumed governmental immunity. Sovereign immunity applies to the U.S. government, and so federal agencies, federal boards, and then there's also state governments. States are considered sovereign as well, and so that is part of sovereign immunity. There's also another subset of immunity called governmental immunity, which applies more at the local level. So it's below the state level. Cities, counties, school districts, villages, state universities will also sometimes be part of the governmental immunity. It depends on how they are formed statutorily. And this matters because if it's a statutory creature, there are more limitations on the ability to bring suit. And so, as Stephanie mentioned, you need to find a statutory basis to sue. And so, at the governmental immunity level, it's more tenuous. The other aspect of sovereign immunity or governmental immunity is there's two types. There's two distinct types. There is immunity from suit, which is you can't sue the government. You need permission to actually bring a suit, as Stephanie was mentioning. But then there's also immunity from liability. So even if you can sue the government, they might not have liability, and the government has to consent to the enforcement of a judgment against it. They can't have unlimited liability because it's taxpayer money that's at stake here. So there is an immunity from liability that also may apply. Next slide. Further, this dichotomy is further brought out in whether it's the type of claim that's being brought. If you're bringing a suit, a tort type of a claim, the Federal Tort Claims Act will apply, or a state tort claims act or a state claims act, they're often known as. And the Federal Tort Claims Act waives sovereign immunity with respect to torts and certain types of torts. And there is a whole process and a limitation on, a very short time frame for bringing it and things like that. The state tort claims, there are 3 types among the various states, and it depends on what state adopted it, so you would have to look up each one. Some states have absolute waivers of sovereign immunity or governmental immunity. Some have limited waivers, depending on the type of claim that's being brought. And some have general waivers, but then there's exceptions to it where the state does reassert immunity. We are not really focusing on the tort side, although it will come up. We are focusing on the contract side because the leases are contracts. And under federal law, as Stephanie mentioned, under the Tucker Act, Congress waived the government's immunity from judicial claims and contract. But again, it's subject to rules and processes that Stephanie is going to talk about some more. And then for state laws, again, similar to on the tort side, it varies by jurisdiction. So you really have to look and see what claims can be brought. There are some states that have not waived immunity even in contract, but most of them have waived it or waived it to a limited extent because no one would contract with the government if they have no right to enforce it. So who would take on that road contract if they can't get paid for it? Some states waive it. Some states rely just and put it into the contract that there's a waiver contract by contract, but others it's statutory. In DC, Maryland, and Virginia are very local jurisdictions here. There are limited waivers. Next slide, and back to Stephanie.
Great, thanks, Krista. So first we're going to talk about the government as lessee tenant. When you are the landlord, you have the building and the types of claims you can bring. So there are 2 challenges. One, these are just the primary ones, the ones that are most common. One, you can challenge the government's method of procuring the lease. So let's say you were trying to lease out to the government and you felt that something was wrong somewhere along the way. That's a challenge that you can bring. The other type of challenge that we're going to talk about is a claim against the government under the lease. So once the government has, you've entered into a lease with the government, they've moved in, they're the tenant now. What kinds of things arise, and how do you go about bringing a claim? Okay, next slide. So if you're going to protest the government's procurement of a lease or defend your award, there are 3 places you can do it. One is the Court of Federal Claims. The second is the agency, so you can actually bring a protest directly to the agency. And the third is the Government Accountability Office. One thing I wanted to point out is that you actually may have been selected for award. The government may have decided to lease to you and somebody else brings a challenge. At that point, can you intervene? It is important, in my view, to yes, intervene. The agency often has attorneys who have extensive breadth of experience but may not have depth in bid protests. And often as the intervener, you can support the agency in a way where you end up being able together to being able to protect the agency's decision to award that lease to you in a way that is sometimes more successful than if you just sit to the side and let the agency handle it all. Especially depending on the type of year, the agency attorneys and the contract officer may be really tight on time. And it's important to be able to support them if you are the awardee and by intervening. But you do have a number of places where you can bring a challenge if you think, again, if you're the protester and you are asserting that something was not according to plan in the procurement of the lease. If we can go to the next slide. So we're going to talk about sort of bid protest principles and then bid protest grounds. One of an interesting way that sometimes parties have been successful in bringing challenges to the solicitation was when the lease that was awarded was greater than the area that was authorized by Congress. Now, what had happened was that the owner of the building had tossed in a bit of extra space for free, but the Court of Federal Claims here held that the award was void. And so it's important to always think about when you're looking at what the government can do and the challenges that you might want to bring. Is the government actually exceeding its authority in some way? That's a consideration that you're going to have with governments that you wouldn't ever have with a private party. Private parties, unlikely really to be exceeding the authority that the company would have to enter into the lease. But when you're looking at the government as a tenant, you should always be making sure that it looks like the government is staying within the bounds of its authority. Some of the challenges that you can bring in a bid protest context are pre-award challenge to terms. These actually have a fairly high likelihood of success. These are also, I would say, lower cost bid protests that you can bring to the agency. You can challenge the terms. The terms don't make sense. They are unduly restrictive of competition. The government is asking for something that it doesn't need. So those are the pre-award challenges to terms. You can actually bring a challenge during the procurement if there is a competitive range and if you've been excluded from that. And then you can bring a challenge after award. There are a number of fairly typical grounds, including that the awardee's proposal wasn't eligible for award for some reason, that any discussions the agency had might have been misleading or unequal. The agency, and then a number of challenges where the agency didn't follow the rules that it put forward in the request for lease proposal. So the agency is going to be held by the court or GAO to the terms that it put in the solicitation. It doesn't have flexibility that a private party might have to sort of, change its mind a little, during the process. It's going to have to stick with the rules that it established, and you can challenge the agency if it doesn't do so. We go to the next slide. This is a slide that I'm not going to address in detail, but if you're thinking about a bid protest, it's important to talk to someone early. Timelines are tight. Choice of forum is really important, depending on the record, depending on who's going to look at the protest again, and your options from there. So I'm just going to leave this slide here for the for people to have as part of the slide deck, but I wanted you to understand that choice of forum is an important consideration and can influence both the cost of the protest and your likelihood of success. Can we go to the next slide? Excellent. So in terms of relief, different parties can give different relief. Agency can give, of course, broad relief, but frankly, it's unlikely to. GAO issues a recommendation. One important thing is actually if you actually prevail in your bid protest, but the contract doesn't have a termination for convenience clause, then you're really only going to get bid and proposal clause. So you're not going to get any other relief. So that's a consideration that you need to think about when you are looking at the forum for the type of challenge you're going to bring. Court of Federal Claims can bring any relief, but often it is sent back to the agency for a redo. Next slide. So let's say, okay, you were awarded the contract, it's been protested, you prevailed. Now the government's your tenant. That's great. They're never going to run out of money. They could just print more, but there can be some challenges. And in my practice, what I found is that some of them are just the most basic. That government employees don't respond. This is not a commercial business. They are not competing with other governments sort of to be your, government of choice. This is just your government. So that I find that tends to make them less responsive. The contracting officer's representative is often unable or unwilling to negotiate. Oftentimes you're not able to really evict the government. You're just able to get damages, and even when you do have a claim and are trying to recover damages, the cost of pursuing that can exceed the damages themselves. So, it's something to think about when you are pricing the lease in terms of what will it cost me to be able to, make sure I'm paid what I need to be paid. Can we go to the next slide? And claims are under the CDA, and I'm just going to leave this slide in there. Go to the next slide. So you can have requests for equitable adjustment, requests for and claims. Sometimes it's when you bring these versus just having a discussion with the contracting officer, you might be able to get a higher level of review, which can lead to greater success being paid. But one of the important things is making sure you are careful about how you ask the government for money, because there are lots of decisions about whether or not a certain request for money was a claim or not. One of the things I would actually recommend is considering a cost consultant at this stage. It can be a lot more efficient to really line up your paperwork and get your ducks in a row from the beginning. And that makes your claim much more convincing rather than people finding holes and sort of wondering whether how much more they could sort of take off. And finally, the biggest recommendation is to keep extensive records just as you go forward, because somebody will always want the paperwork, and having the paperwork really does across the board increase your likelihood of getting paid appropriately. Next slide. And finally, there are two different fora. One is the boards of contract appeals. If you're pursuing an appeal of a contracting officer's decision denying your claim, the other is the Court of Federal Claims. There are different timelines, and once you choose your forum, you are stuck with it. You can't sort of change horses, using a reference kind of typical of the Tucker Act. You can't change horses midstream. So both of these, if you don't like the result, you can appeal to the Court of Appeals for the Federal Circuit, but there are two fora and they come with their own considerations. So talk with someone before you submit your claim.
Okay. One thing I just want to add, if you are a private landlord renting to a government agency, and if you are intending to sell the building, start early. Getting a statement of facts or what you would need for an estoppel certificate for normal commercial transactions can take up to 90 days. They are not usually beholden to the fast turnaround that most private parties are used to and would go in a normal commercial lease. And then you need to get the lease novated to get the payments made to the new owner of the building, and that is another process. So don't think that just because you sell the property, you send a notice of assignment over to the government that they're going to abide by it and start paying the new landlord, the new owner of the building. That does not happen. You need a novation of the contract. Just want to make sure that those challenges are addressed, because for the uninitiated private landlord who thinks that they have the ace in the hole with a government tenant, getting off the payment stream is sometimes as hard as getting it going. Anything to add to that, Stephanie? You're smiling.
No, you're absolutely right. Yep, it's novation, and generally you have to get permission, express permission to novate. And sometimes they need even extra time.
That's absolutely right. And 4 or 5 months is not outside the realm of possibility for an ovation agreement. I will turn to when the government is your landlord and negotiating a lease with a government agency or the government itself. And there are kind of two challenges that I'm going to really touch on today. One is enforcing remedies against a landlord, and then just the slew of additional provisions that get thrown into a normal, what would otherwise be a normal lease. Next slide, Brooke. So the first one, liabilities, indemnity. So there's a breach, there's a repair that's needed that the tenant ends up making itself. There is a slip and fall where it happened on the land and through no fault of the private party tenant. Under normal leases, there would be an indemnity agreement with the landlord. The landlords want to protect against open-ended liabilities. A sovereign, a governmental agency can't have an unlimited obligation to pay. They are limited by taxpayer dollars. So they want to use this sovereign or governmental immunity as a shield against having to pay beyond what they have in their coffers. And especially local governments have very strict limitations on, there's no deficit spending. So typically if there's like a slip and fall or something, it's a tort action. I fell on this land. Well, the Tort Claims Act would normally apply, except you're seeking indemnification, which is a contract claim, and so you're actually in the contract realm. So it is very typical for government agencies as part of their leases to insert limitations on any tort type claims that are brought through indemnification provisions. So they get the benefit of the limitations on sovereign immunity, meaning oftentimes the claims are limited to $200,000, $400,000. There's limits on how much the actual damages payout could be, or the time to be brought for the suit to be brought. So they will agree to be sued, but it's 6 months, it's a year. It's not the standard private party statute of limitations. And because of that, this becomes a very tricky issue to negotiate and one where careful drafting is recommended. And then they will also add in government landlords are limited to the annual appropriations. So they're not going to readily agree. And frankly, payments out to you for any liabilities are often subject to appropriations. So the answer to this is often add more insurance to it and make sure that the insurance will cover and be the main basis and the source for recovery. Next slide. And finally, as I mentioned, in addition to the appropriations language, government, when they're your landlord, will add in a whole bunch of additional provisions that are not normally seen in leases. Non-discrimination in who you let into the building, who you employ in the building. They will have no gifts or gratuities to the landlord, no contingent fees, no they will add in anti-bribery language. The officials might not benefit, so there's no personal payments or otherwise for services rendered by the private party landlord. They'll add in a preference for local vendors sometimes, especially for state agencies, and it's very typical that they will put in a specific venue that's local to them for suit. So you're not getting sued in a forum of your choice. You will be sued where is convenient for them and is usually very sympathetic to them as the government. And finally, there's often an arbitration provision that's in there. I know we're at the end of our time today, and we thank you for your time and attention here. We know we just kind of skated the surface of this. For those of you seeking CLE, the CLE code is S for Sam 4341. SS 4341. I see no questions in the queue, so we will end right on time. If you do have questions, feel free to email either Stephanie or me, or give us a call. We are happy to answer any questions you have. And again, thank you for your time and attention today.